Hello, I'm Stuart Evans. I'm a partner in the Commercial Advisory Group at BLM. Today, we're going to tackle the following question. What if my business has claims against other parties as a result of COVID-19? To discuss this critical question, I am delighted to welcome Jennifer Meach, barrister at the leading commercial chancery set, Enterprise Chambers. Jennifer, welcome.
Thank you.
Jennifer, to set the scene, there will be countless instances where the supply chain has broken down, leading to non-performance, delayed performance and cancellations. There may in many instances be a direct result of COVID-19, but not always. How do you sort out the fair excuses from the convenient ones?
Well, it's a difficult commercial assessment, and you will need to think about this supplier, how they've dealt with their obligations in the past, and also, of course, whether you want to deal with them in the future. If they've generally been reliable and you do want to deal with them in the future, then it may well be sensible to give them the benefit of the doubt.
That's certainly a sensible approach. One term known to lawyers for many years, but usually on the subs bench until now, is force majeure. When can that be a fair excuse for a failure to perform?
A force majeure clause in a contract deals with the consequences of one party not being able to meet their obligations because of an external factor. So fire, flood, or of course, in this case, pandemic. They appear in lots of commercial contracts, but they are, as you say, rarely looked at. Anyone who has the benefit of a clause providing that in the case of pandemic they don't need to comply with their obligations may feel very pleased with themselves, but they need to bear in mind that the courts construe these clauses very narrowly, and they will need to be looked at very carefully. And of course, as a matter of fact, you'll need to prove that it was the pandemic that caused the difficulty.
I agree. You always need to show that it is the pandemic that's preventing performance rather than another factor. And of course, a valid force majeure clause may only excuse performance temporarily. So depending upon the precise contractual obligations, those can resume once normality returns.
Yes, you'll always need to look at the particular clause. It's going to be very interesting to consider contracts, for example, relating to particular one-off events. If they don't specifically state that time is of the essence or make very clear that the event has to take place on this particular day, would performance within 6 months be possible, or in 12 months? It's going to be very interesting.
I think we both agree that if there is a dispute, there may be scope to negotiate a compromise solution or look to another supplier. But for those looking to progress a claim through the courts, what are the options?
Well, the courts are operating very differently at the moment. The High Court, particularly the business and property courts, are operating more or less as usual in that because of CE filing, you can still start your claim and file any applications you need to. And in the Chancery Division, the Applications Court is running remotely and, as far as I understand, very smoothly. The county courts are another matter. They are struggling because of a lack of staff, and your advisor will be able to assist you in whether a claim can be started and which court it will have to be started in at the moment.
And what if your opponent is cash strapped?
Well, you can think about insolvency proceedings. I know you and I saw a press release a couple of weeks ago from the government saying that winding up petitions would be banned for companies that couldn't pay their bills. The headline related to landlords, but the wording was much broader than that. As far as I'm aware, there's been no legislation or practice direction bringing that in. But again, something to discuss with your advisor, whether you want to present a petition at the moment.
Yeah, we'll certainly be picking up on insolvency in future editions. So just to say, if you have any claims or are concerned about the state of your business, get professional advice early on, as difficult situations can be turned around. Jennifer, thanks as ever.
Thank you very much.
If you have any questions or need specific advice, please do get in touch using the details on this page. Look out for part 3 in our What If series, focusing on statutory demands. Until then, Stay safe and thank you for watching.